Today I'm excited because I really do like this type of format. It's myth busting. So we'll take a couple of topics that have come up recently that you may have even believed to be true in the past. Um, and we'll just kind of go through them. And I do already see someone had a question about the NAR lawsuit. We'll add that to the list. We'll talk about that as well. But these are, generally, I really like this because this is what law school taught us, which is don't just take things at face value. You actually can learn and do the research. You can get educated about it. And it takes work. It takes doing the hard stuff to learn about it. But it's a really important process because without it, you tend to not have control over what you believe to be true or not. Dad, did you have one of those realizations at all? I know you and I have talked about law school in general, but the big wake up call to me, the reason why I really wanted law school was I liked the idea that it was going to give me the skills to kind of find my own answer.
Yeah, my wake up call was from a family member. But once I got into law school, I had a classmate whose father was very famous in Miami, and he defended a young man against some crime, and his defense was TV intoxication. And that was my aha moment that I can make up whatever the heck I want. I mean, everything's gray. There's a lot of ambiguity. It's only limited by my own creativity and I guess nerve.
Yeah, nerve's a big part of it. You gotta have the strength to then act on that education, that research.
Yes.
Yeah, I love that. So we'll get into that NAR lawsuit maybe a little later, but what I wanted to start out with was the big one, which is something we see all the time. Actually, I'm going to add another one to the list. I just threw my pen. I have another one, luckily. And I'm going to add another one to the list as kind of like a subtopic. But the big one I wanted to talk on was anyone that's buying a property, they're told either online or by a family member or a friend, maybe even you're telling your own clients this, you should own it in an LLC, right? A limited liability company. And Dad, before I kind of get into the, what I believe to be somewhat of the myth or why they should or why they shouldn't, do you mind kind of opening that up and telling us when you see people buy it in an LLC, when it might be a good idea in your mind?
When would it be a good idea?
Yeah, why would someone want to own something in an LLC? Why is that? Why is that an idea?
Well, there's business and there's tax advantages. The tax advantage is the easy one. There's a flow through of income and deductions, so it's treated somewhat like a partnership.
So it's tax like benefits.
Yeah, and then they litigated that with the IRS for years and years before they codified the tax advantages. So LLCs are good. But for tax advantages, you can do certain things with a flow through LLC that you can't do with an S corp. You can have another corporation as a member,
or even differently, things that you could do if you that you couldn't do if you owned it individually. So I always look at, say, the rental, and let's say you live in Massachusetts and you buy a rental down here in Naples, and you fly down here every 6 months to check up on it, to make sure it's working correctly, and you have a lot of cost involved in that. We're not accountants, we're not tax attorneys, but it's a possibility that some of that could be deductible if you're running a business and you have revenue offsetted by expenses.
And it keeps things somewhat separate. I mean, I had a client with 10 different restaurants, and he would put each restaurant in a separate entity. And that way, if there was a slip and fall, if somebody choked on a chicken wing, it would just, the only thing exposed would be that one restaurant, not all 10 of them. So,
a liability protection.
Like that. But the number one source of those questions tend to be accountants for some reason. I get people and they want an LLC, and I ask, well, why? And says, well, my accountant says I should have one.
Right.
And then I have to go into my standard spiel on what they do and what they don't do. And they're often surprised by what they don't do. They think it's going to protect them from lawsuits, and it's not necessarily.
So let's go through two different scenarios. Now,
Mm.
this really, in my opinion, this is the main driver why people are given the advice to open an LLC. I think you touched on the other one, which is taxes. Obviously, if you're talking to your accountant, that's what they'll think about. But the big driver to me is that liability piece of it, which is, all right, situation number one, I have a tenant who lives at the property. They throw a big party, someone gets hurt, and they sue the owner of the property. In that
Right,
scenario, that's owned by an LLC, they're
right.
going to sue the LLC. What does the LLC own? The LLC owns the property. It might have a bank account. It might have an insurance policy, but it doesn't own your home where you live back up in Massachusetts. It's separate. It limits the liability to whatever the value of that LLC is in a perfect world. Dad, you and I, we're not going to get into the details of like piercing the corporate veil or any of that stuff. We're just going to look at if it's working correctly, then this might be a good thing for that scenario, right?
It raises another barrier. It's not bulletproof,
Yeah.
but it's just
It's
another
it's
option.
better than nothing. It's something. The other scenario, the one that people probably don't realize is, all right, you own it in an LLC, the tenant's doing fine, but you get in a car accident or you do something personally, maybe at work or wherever, and there's a lawsuit and a judgment. Is there any protection against what
No.
you own down in Florida in that case?
No, you have post-judgment discovery. After I get my judgment against you for $1 million, we have a deposition, and I ask you to bring in copies of all deeds, all shareholder agreements, all operating agreements with LLCs, all trust agreements,
Yeah.
anything you might have a legal or beneficial interest in. And you have a beneficial interest in the LLC. You're a member.
Right. You own shares in the LLC or whatever, or S
Essentially,
corp. Any of these corporations or companies would work the same way, where there's that limited liability. I would say it's similar to owning stock in Apple or Amazon or Facebook. Whatever happens at Facebook stays at Facebook. The worst that could happen is your assets get drained. Your investment goes to zero. But if get in a car accident on the way home from work, it doesn't matter that Apple is incorporated. You're still gonna, you'll still have that personal
well,
liability.
even looking at the real estate brokerage company, I mean, I have a stock certificate showing that I'm a member and your mother's a member, and it's a certain percentage of the company, and so it's an intangible asset that is sellable subject to the membership agreement.
Yeah. So there's your reasons why you might want to do it. There's one reason, there's that first myth that we're busting, which is it's not a perfect protection. It's really not perfect, but it's probably better than nothing. Now, the real myth buster that I like to bring up when people ask for this is, well, why wouldn't I want to do it? And there are
Well,
really two main reasons, maybe three. Let's say three. And I'm going to take my notes while I'm doing it so I don't forget. But reason why I wouldn't do it, number one, is if I have a mortgage. So if I have a mortgage, and this is kind of 1A and 1B maybe, number one, the mortgage has a due on sale clause. The St. Germain Act specifies that you cannot sell this property without paying off the mortgage first. And
right.
selling is defined as any sort of conveyance, either in part or in whole. So if you sell half of your interest to your friend or your brother, or if you put the whole thing into an LLC or an S corp, it could or it does violate the due on sale clause in your
Yeah.
mortgage.
It doesn't
And
even have to be a sale. It's just a transfer of the interest.
just a transfer in full or part. And
Right.
there's always feedback. They come back, oh, but does that really happen? Probably not, right? So we'll get out there. Very few banks will actually put you in default if you put it into an LLC. I
Well,
don't see it
these
that
days, I
often.
think banks are looking more closely. I mean, you can look at somebody who bought a home with a 2.5% mortgage, and then they
Yeah,
transfer a portion of it. That
right.
bank wants out of that 2.5% mortgage. They want it paid
Yeah.
off so they can lend it at a higher rate.
Absolutely. And what we usually see is even if they're not going to put you in default, they can send you a nasty letter. And we usually see that when they're doing some sort of audit analysis on insurance or taxes. So every year, they're going to make sure that the taxes are paid and that the insurance is paid and up to date. And if they notice on your insurance policy that you're no longer listed as the beneficiary of the policy, they're going to start asking questions. And then they're going to put you into the audit department. They're going to put you into some sort of default. That's just what they do. They're not looking for trouble. The trouble found them. And that's not so great, right? So I always make sure that the client knows that there's always a risk, even if they're willing to still take that risk. That's a risk that they have to make. The other side of it,
I
yeah,
usually suggest to the client that they just ask their lender, do they have any objection to transferring, partial this into an LLC, and my wife's going to be a member, or one of my kids, or my business partner. If you get an email back from the lender saying it's okay, then you just have to worry about doc stamps.
yeah, email. So email is what we would want, or something in writing. At minimum, something from the loan officer, but potentially something on like formal letterhead saying that we don't object to you conveying this into your solely owned LLC. I have seen it. I would tell you most people don't even go that route. They just kind of do it and they ask for forgiveness later. Now you touched on the other topic, which is the doc stamps. So how do we calculate that? So you have a property. Let's say there's $1 million mortgage. Let's make it smaller. Let's make it $100,000 mortgage on this property. The property's worth $200,000, and we want to put it into an LLC. How would we calculate the doc stamps on this transfer?
There's case law, and there's the Division of Insurance regulations. I mean, if it's to your spouse or if it's a gift,
We're going to put it into the LLC. So LLC, what do? They calculate it on the value of that mortgage.
The fair market value of the property. But there was a case, and we had this in the office, where it was a John and Mary Smith. That was their real names. Honest to goodness, the guy was a doctor. Who were transferring it as John and Mary Smith as general partners to John and Mary Smith, husband and wife. And the Department of Revenue tried to impose a tax. And they do the same. They did the same thing for years with LLCs. You have to fight it with the Department of Revenue. You have an administrative hearing.
Well, let me stop you there, because I just want to make sure that we kind of explain to everybody what we're trying to figure out. We're trying to figure out, if you transfer the property from one party to another, was there consideration paid, right? So consideration paid, what you're going to get into was the scenario where, the husband and wife are transferring it into or out of their LLC. Nothing, basically a gift. They're transferring the ownership in the property for ownership in this LLC, and they're making the argument whether there was consideration or not.
Yes.
Short of that, let's put that aside. Let's say that may or may not be consideration. Let's say there's a mortgage, right? There's $100,000 mortgage. In the very least, the consideration is the principal balance on that mortgage. So if it's $100,000 balance on the mortgage, that's your consideration, and they will charge you $7 per thousand on that transfer. So that's a $700 transfer to move the property into an LLC. It's not nothing. And
it's relief from indebtedness, so they whack you for the whole 700 if you're getting the whole beneficial interest.
Yep, consideration. So I've got this website that I'm sharing. I hope I'm sharing it. And it talks about, this is the Florida Department of Revenue. This is what they look for. They look for money paid or to be paid, the discharge of an obligation, aka the debt, the mortgage, exchange of property, real or personal, the mortgage lien or other encumbrance on the property, whether assumed or not. So even if the LLC didn't assume the mortgage, which most of the time they do not, they will count that as consideration. So let's say it's not a $100,000 mortgage, but a $300,000 mortgage. Well, now it's 300 times 7, so it's a $2,100 consideration. That's just the tax to put it into the LLC, and that's after you're taking the risk on breaching the mortgage potentially, or whatever other concerns you might have, insurance or otherwise. Then you gotta set up the cost. So there's a cost with the LLC. I think you do it through the Secretary of State in whatever state that you're doing it for. We do a lot of them here in Florida. I've done them a lot in Georgia and other states, but generally, let's look at Florida. It's $150, $135 to set it up. And then, it just gets kind of complicated. You've got potentially, if it's a husband and wife that own the property, it's not really a disregarded entity for tax purposes anymore. Now you have a tax return just for the LLC. Your accountant's going to be charging you more. And is that true, Dad? That if it's husband and wife as the two shareholders, could that still be considered disregarded or no?
It would still be disregarded. Then those are situations where I question whether it's even worth having the LLC because you're paying
Well,
for a
that's the
tax.
point. That's the point I'm making is we're piling on here. So someone told you that it might be worth it. And now I'm saying, well, you got this risk, you got this downside, you have this cost, and you have this ongoing issue. And oh, by the way, when you sell it 10 years from now, you're not going to remember how you set it up, and you're going to drive yourself crazy trying to find the paperwork. So I guess that's the point is LLCs are good. They're not great. There's a cost. If you're buying it cash and it's a rental, and this is something, you have an accountant, you have an attorney that will help you, that you have us that'll help you. Yeah, we can make this as easily and pain-free as possible, but it's not nothing. There's definitely a cost.
I mean, the one biggie is advantages if you have multiple owners, like our last office. If you have 5 or 6
Thank you.
owners,
Yeah.
you need to have some agreement on who's gonna use what portion of the property, who can convey what portion of the property, how does the property get disposed of, it's sort of like the guts of a trust.
Yeah, so let's talk about if you didn't do that, right? So this is a part that I think you put all that stuff aside and you say, well, I'm doing it because we have to, right? So let's say you just have two partners, you and your best friend,
Right.
and you're going to buy a rental property. You're going to use it some of the time, they'll use it some of the time, and then you'll rent it the rest of the time. I think it happens quite frequently. In
Yeah.
that scenario, we want you to own the property through some sort of entity, whether it's an LLC or a corporation, because we need you to take away the risk of personal liability, like that person's life impacting your ownership of this property. And I'll give you a couple of examples. Let's say you and your buddy own it and your buddy gets a divorce. Well, now there's potentially some argument as to who even owns his portion. Is it, can you sell it while they're getting divorced? Or worse, Dad, we talked about getting in a car accident. Something back at home creates some sort of judgment or a liability. Well, it's going to attach to anything that person owns individually. Now, Dad, if you owned, so in that hypothetical, I get in a car accident, they sue me and they get a judgment, and it attaches to everything I own in that county or wherever it's recorded.
Right.
So it's going to attach, to any property, maybe not my homesteaded property, but anything else. Well, this is a rental. This would attach, right? Even if I own
It
it
would
with you.
attach, but we could put something in the operating agreement on what my rights would be if something were to happen to you, or if
Well,
a judgment
yeah.
against you.
So it would attach if we owned it individually, but it wouldn't attach if we just own shares in the company and
It
the
doesn't
company owned the
attach to
real
the
estate.
LLC,
Yeah, it
but
wouldn't attach to the
when they
LLC.
get into post-judgment discovery and they ask Christian, "Well, we bring in
What do you
everything that
own?"
you own," they're going to look at it and see, can we take this interest in the LLC?
Yeah.
And they're going to have to look at the operating agreement and see what my rights are. Can I buy you out in that situation?
Yeah.
Because I don't want to be partners with ex-wife or, whoever you ran
Yeah.
over.
So you mentioned an operating agreement. Just to dispel what that would be, it's basically a partnership agreement.
Yeah.
It can be
Shareholder.
1 page or 100 pages, and it specifies who makes certain decisions, when things have to be voted on, what the purpose of the organization is, who owns it. And they're really kind of neat because let's say, Dad, you and I were partners on a deal and we're 50-50, right? You own 50% of the company and I own the
Right.
other 50%. Well, we could change it so that yes, we're 50-50, but I make 100% of the decisions. I'm the manager. I can override
Sure.
any decision you make. And that's actually not that unusual. It probably should be done more often because if you've got an even number of people that have to come to a unanimous answer on certain business decisions, you're probably not going to make many decisions. So
Right.
I kind of like the idea that, you have, how do we allocate ownership of the company? How do we allocate profits and liabilities of the company? And how do we allocate business decisions of the company? So
I
those things
think
are
it's
done in
wonderful.
operations.
See, the problem, like with you and I owning something together or friends owning something together, there's a lot of conversation that just is not conducted. And by having an operating agreement, the lawyers are forcing these friends, family members to conduct these conversations on what happens if Christian wants to sell his interest in the property because he has a big tuition bill coming up for your eldest daughter. And I may not want to sell because of tax issues or some other situation. So it forces friends, family members to talk about situations where they just assume the other side is going to do the right thing, whatever subjectively you think that might be.
Yeah.
And you're
I
right.
like to
That's
always
different.
say our job in that scenario is to ensure that you can still go to Thanksgiving dinner together. You may not
Yes,
want
yes.
to talk, but you can both be in the same room without killing each
Well,
other.
if you have a rental property and you're using it and somebody spills something on the couch, at what point can I say, when are you replacing the couch?
Right.
Yeah, and I don't want to get in World War III with my son or his wife or my best friend, but the lawyers force us to have that conversation so we remain good close family members or good friends.
Yeah, yeah, that's great. I love that. All right, so there's our myth busting number one. LLCs and corporations can be really great for certain situations, but they're not perfect for everybody. And more often than not, I'm talking people out of doing it than I am convincing them that this is a good idea. So keep that in mind. That's an interesting one. All right, so the next one, I don't want to get too into the weeds on this, but it's something, Dad, you and I are working on for an article. But mixing forms, right? So you've got neighbor, you've got far bar, and you've got far. Now, Dad, you and I talked about this. I didn't set you up, but I asked you this hypothetical question, and this is a tough one, and I'm going
This
to
is
put the condition.
yesterday, right?
Yeah, this was yesterday. I'm going to put the condition in advance. Talk to your broker before you do any of this, right? It's really not our decision to make regarding your business, but I do want to put it out there. So the hypothetical is a Lee County property, right? So in Lee County,
Mm-hmm.
um, we're going to put a property on the market for list. We're going to sell it for a seller. And the first question is, and this is what I asked you yesterday, try and answer the same way because don't set me up on this.
I got to remember my name here.
So listing agreement, what form would you use? And
I'd use the FAR one because that's what's common up there.
a FAR listing agreement. All right, so we got a FAR listing agreement. It's not what you answered yesterday. Number two, seller disclosure. What form would you use on the seller disclosure?
I would probably use the FAR seller disclosure and augment it with mold and radon because it doesn't
So,
have.
and the reason why you can't use a FAR bar is it doesn't exist. There is no FAR
It
bar
doesn't
seller
exist.
disclosure.
I try to tie it to, what the other agents used to and what is going to be in the contract. I know yesterday I probably said neighbor listing agreement
Yeah,
because
so we'll do that one. So it doesn't matter though, because it really doesn't matter. The point will still be made.
yeah.
The next question is, all right, it's in an HOA, and it's in a condo. Let's say it's in both. What rider are you going to use?
I love the FAR bar A and B because it's more comprehensive and a lot of the issues like with the condo come up frequently, special assessments that they've been talking about. We get that quite a bit.
Yeah.
I'm tired of
Well,
answering
and
those.
you said this previously. Um, the big reason you would use a FAR bar rider A and rider B is that you expect to get a FAR bar contract. You're in Lee County. So that's
And
more likely. So you're not going to spin your wheels and put together an addendum for HOA disclosure on a NABOR form because most likely you're not going to use that. You should be
yeah,
expecting to use a FAR bar
I mean,
contract.
I would tweak the rider because I think the condo rider doesn't request the governance form like the neighbor contract does. So I'd make minor tweaks like that.
Yeah,
Uh,
so we'll just kind of summarize that, and it's like, all right, now we're talking about possibly using a NABOR contract, a FAR contract, and a FAR bar contract all in the same listing. Because ultimately you're going to get maybe a FAR bar sales contract when someone makes
Right.
an offer. And I have heard, and we've talked about this at length with several brokers, is that that causes some discomfort because we're like, now we're mixing forms right off the bat. And the myth bust, I hate to break it to everybody, but yeah, you can mix forms legally. You can mix forms. In fact, if Dad, if you and I wanted to make a contract between you and I, here we go. We've got the Ross title form. We can use that. It's legal, except you learned something yesterday that a couple of brokers told you about what they might need to do that. Can you remember that?
Yeah, I mean, I called a number of brokers that I deal with, and they don't, as a general rule, they say no, don't mix and match forms. It's safer, okay? It's safer for the realtor. It's safer for the seller. You're not going to have an inconsistency. The if you use the FAR seller disclosure with a NABOR contract, that doesn't say squat about the radon and mold, yet it's a defective item in the NABOR contract. So, somebody can make noise about that. So they don't want people inadvertently using a form like the pre-closing or post-closing occupancy FAR bar form in a NABOR contract, because those forms refer to paragraph 12 or 11 in the FAR bar contract.
Right. But
So
what do they ask you to do? What would most brokers ask their agent to do if they
they,
found themselves wanting to mix and mingle?
they want a letter from a lawyer saying this is
Right.
okay.
Right. So that's something we could help with. I
Absolutely.
hesitate to even talk about this topic because it's really not supposed to be confrontational, and I don't want to get in the middle of a sales agent and a broker. I think it's the broker's business. They need to regulate it the way they need. But if they are willing to do it, they would only be willing to do it with an attorney's approval, which we would be happy to help with if that came up. But just realize that there's that natural issue there. And in the scenario that you and I talked about originally was like a NABOR listing, a FAR seller disclosure, and a FAR bar rider A, which is the condo disclosure, and a FAR bar rider B HOA disclosure. And it sent the broker for a head spin. They're like, what just happened
And
here?
this was Lee County property, wasn't
It
it?
was Lee County. So it actually made
Yeah, so
sense.
that's what
And
they're
it
going
made
to see when
sense.
they sell it.
It made sense for this reason. The NABOR listing agreement is what the agent was most familiar with. So that's what they wanted to use.
Right.
There is no FAR bar seller disclosure. There's only a NABOR or FAR seller disclosure. So they chose the FAR seller disclosure. Again,
Right.
because it's Lee County, because they weren't expecting to use a NABOR contract. And then
Right.
because they're using a FAR bar contract, ultimately, they wanted to make sure they were prepared for rider A, rider B. They could easily switch to doing the HOA disclosure on a NABOR if that was required. So it was just an interesting topic. I know everyone is usually trained not to mix and mingle as a general rule, but myth bust, it is doable and it does happen. You just need an attorney to be right there with you and kind of guide
I
with.
mean, it doesn't happen all the time, but once in a while there's a reason for it, and it's
Yeah,
just nice to know it's possible. You just need to call a lawyer, but you do it for a reason. You don't do
do
it
it for a reason. Yeah,
for giggles. The me liking the comprehensive rider for the condo, I've never actually done that with a NABOR contract. Why? Because we have the 3-day rescission anyways, and I can get all the information during the 3 days. So I'm trying to make it simple, and I'm trying to get the offer accepted.
right.
But if I were taking a law school exam, I like that rider better because it just gives me more information. It's
Yeah,
handed to
it
me
does.
rather than
In the
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 phone.
additional, there is more information on rider A. There's a lot more information.
It's three
So it's
pages long, so
yeah.
versus one paragraph. So yeah, there's
So
a heck of a lot more information.
Vicky asked a couple of questions. She said, "What do you do if you just don't have that form for FARBAR? If you're looking for it, it doesn't exist." So what we get a lot is that these agents that are more used to NABOR, for example,
Right,
NABOR has a million forms. They've got forms for pre and post closing occupancy. They have forms for financing. They have forms for pretty much any contingency you could think of. Whereas FARBAR is pretty bare bones. There's very few add-ons that are available. There are a couple of tricks, Vicky, and here's what I tend to use. Number one, you really, make sure that you're working with an attorney to do so that you're doing it correctly. Make sure that you
Right.
have your broker's input on it. But generally, you have a couple of tricks that I like to use. Number one, you can copy the language from the neighbor form that you like. Make sure that it doesn't, reference paragraphs that don't exist in your contract, but you borrow that language and you paste it into an amendment for FARBAR. I really love that option because it's well thought out. You like the form already, you just need the language.
But have a lawyer bless it. I mean, that way you're not practicing law and you can say, I consulted with the so and so. I mean, I get a lot of people who will say, is this language okay?
Yeah.
And as long as and I'll tell them, make a note to the file that you sent it to me and I said it was all right, and I'll back you up.
Here's
Uh,
a great example as well. So I like the escalation clause that NABOR has. It's my favorite, right? In this hypothetical, let's say NABOR is my favorite escalation clause, but I'm using a FARBAR contract today. I'm going to look at this and I'm just going to, let me
Place
see,
right there.
copy. I'm not seeing anything in here that references any other paragraphs. It just talks about, it has a couple of, capitalized terms. But this, I think you could probably just copy and paste this. So that's the example. Obviously, run it by us. We'd be more than happy to help on something like that. Um, Kind of a neat little trick when dealing with something difficult like that. All right,
Yeah.
next fun topic. This one I had to do a little research on, and I don't know if many of you have had this issue, but what happens is permits, right? So we've done classes in the past on permits, and I got this myth buster earlier. They said, well, if I do owner permitting, so no contractor involved, the owner applies for it.
Right.
I heard that there is a restriction on selling the property after you do that, that you have to wait 2 years. And I'm thinking, that's never come up. In all the closings we've done, we have never heard that.
I've never heard of that.
Yeah. So, but it doesn't mean it's wrong, right? So I
Yeah.
started doing some digging. Let's see if I can share my screen again. I
Isn't there
did
one on
find
seventy-five
several
thousand
things in
dollars?
here. There's a lot of information. This is not just Collier County. This is not just City of Naples. But I really like this form that City of Naples developed, and it does a really good job of explaining it.
Refers to a Florida statute,
Yeah, it is a Florida statute. So here's the
198
background.
something.
Generally, the rule is you have to be a licensed contractor to pull a permit, period, right? That's the rule. But there's an exception to that rule if you are the owner of the property
Yeah,
and
there's
it
the
does not
75,000.
exceed $75,000, right?
Yeah, I'd heard of the 75,000 rule.
Then there's additional contingency on top of that. Let's see. It says that basically you do not intend on putting the property up for sale or lease within the next 12 months. I don't know where that is. I'm skipping. Oh,
Make
here
sure
it
it's
is.
the owner's home.
Right. So they're saying if a building or residence that I have built or substantially improved myself is sold or leased within 1 year after the construction is complete, the law will presume that I built or substantially improved it for sale or lease, which violates the exemption. Right. So this is the form that any builder, any owner would have to sign. I believe there's a signature on the bottom here. Yeah, they'd have to sign it. And then they would be issued that permit and be allowed to kind of work through it. Now, this is where the problem is. It says, look, if you're doing a owner permit as an exemption to this rule, the general rule, you could have some problems selling or leasing the property. So I did a little bit more digging on it, and the reality is I don't know how it's enforced. It may not be enforced all that well, but if they found that you did this, I think you would probably get hit personally. I don't think it would be something that would necessarily attach to the property long term. I don't think it's something that would hold up a closing necessarily unless the
It's
buyer
not a title issue.
discovered this. It's not a title issue. It's like a code violation or a lien or an open permit type thing where they'd put some sort of status update on the permit itself saying that this is a major issue. You can still sell it. There's, it's just that the owner that did this would have some real, have a reckoning at some
Well,
point in the future.
question that you too, I mean, permits have only been part of the NABOR contract for less than 7 years. So that's number one. So it's still new and people are still trying to figure out what's important and what's not. And we have this curative statute. And secondly, anybody who's ever done any work and had a permit pulled, they have to assign a dollar figure when they're applying for the permit on the value of the work being done. And I have seen more than my fair share of instances where the amount of work being done is way more than what's on the permit.
Yeah.
So
Yeah.
that's great. What's put in writing is a great exaggeration from what's actually spent
Yeah.
in most cases.
Yeah. So
Because it's
it's
added to your ad valorem taxes, so
right. Well, and that's the thing. You're going to be reevaluated based on what kind of work you're doing. Yeah, Kim mentions 75,000 is basically nothing. You're right. I think, this is per permit, so you could stretch that out. You could do 100
I've
if
never
you
seen it
wanted.
picked up. I
I
honestly
haven't
couldn't.
either. But here's where it came up, and this is where I want to really dispel the myth. We had a closing where the permit was pulled and then the contractor went out of business. This happens quite frequently. The permit wasn't closed, and now the
Right.
seller's kind of scrambling for what do I do next? So what I recommended is I said, all right, let's go down to the county and let's apply to make this permit changed over into the owner's name. And that way the owner can then schedule inspections and get it closed out. If there's work that needs to be done to fix, we'll hire that out for a sub or whatever, but the owner will be the contractor in that scenario. And the realtor kind of said, wow, that's great, except we're trying to sell the property. We can't do that because there's a restriction. And that doesn't work that way. I said, don't worry about it. So we didn't pull the permit hoping to sell or lease the property. We're just trying to clear it out. Think that's a distinction that could be easily figured out. And that's not something where you get your hand slapped. And also the work's already been done. That was the other thing. It was a fence. I suppose it depends on the circumstances, but I wouldn't shy away from that being our solution when the contractor can't be found and it's such a silly thing and all you need to do is get the final inspection. So it's a great option. It's a great option. I was actually thinking of doing it for my house, Dad. I've got an open permit on my house. It's expired. Contractor went out of business. The work was done and it's just sitting there. And I'm thinking, no, I'll go down to the city. I'll open it up, get it transferred into my name, and then schedule the inspections. And then you'll fix it for me, right?
If I pulled the
Don't even
permit
answer.
my father did to the house, I would be broke.
All right. So the last topic that I wanted to talk about was something that I probably will just skip over quickly, but someone actually brought it up a little bit. Says, does this apply to condos since they are commercial properties versus single family? Yeah, it would apply to condos as well, because even though the building might be considered commercial, the residences are residential. I think that distinction wouldn't be lost on permitting. The reason why commercial doesn't work is that very few people own commercial buildings in their individual name. If you own it in an LLC, you could not be an owner permitter. You just couldn't do that. So it would have to be in their personal name.
See, this permit thing would not show up in a title insurance commitment because they don't cover building code
right.
situations. They don't cover.
I think it would pop up in a permit search. That's where it would pop up potentially, but maybe not until after the fact. So I don't know. I haven't seen that be an issue. I really haven't, but I wanted to bring it up. I think we'll probably skip this topic for another day, but I'll talk on it really quick. Condos. The myth bust on condos is they're not easier. So most people want to downsize or their second home, their retirement home, whatever it is, they want to shrink and they want to do a condo. They don't want to have to worry about the grass. They don't want to have to worry about maintenance. And they just think it's just an easier way of living. Maybe not. What it is it's more expensive. You don't save on cost, right? And what we are seeing over the last 12 months is condos that were really affected by storms, they continue to be like really struggling to get repairs done, to keep their finances in check, to keep insurance in check. I think if you're going to downsize, just don't be disillusioned about condos. I think some of them are great, especially more inland, the ones that are well financed, the ones that have great boards, great property managers. But not all condos are created equal. Some of the older condos that need a lot of work, they're a little bit of a headache. And I know I'm not doing anyone any favors in this market by saying that, but just be careful. I think condos, we're dealing with so many property managers that don't know really how to operate, and they're making decisions on insurance that affect your ability to get financing. And if there was another storm, you could have some real insurance issues. I don't know. Dad, have you seen, I mean, you've seen condos in this area for the
I
last
mean,
30.
I've talked about condos with your mother actually, and there's just no way it would fit our lifestyle. You lose a lot of privacy. You have to comply with their rules. And unfortunately, somebody like you or me, I mean, we'd have a heck of a time being told what we can hang on our front door in the hallway. I just don't think I would do well. I know my father was looking at, I think, WinStar at one point, and when he saw the rules and regulations, he just knew he would not get along there. So
Well, I
it has
think
to be your personality.
that's something that you and I have talked about a lot, and that's always there, right? Remember, my
Yeah.
brother had a condo, and he couldn't park his pickup truck in the driveway, it drove him crazy. But even if you're beyond that, just realize that when you're looking at condo docs, when you're evaluating a condo, it's more than meets the eye. There's really, looking at the meeting minutes, it's one of those scenarios where the FAR contract probably gets it right, where they make the seller disclose meeting minutes going back 12 months, or I think it's special assessments in meeting minutes over the last 12 months. Because
Right.
it does matter. It's not just this snapshot in time that gives you the full picture. You've got to really look at the totality. And I've told this story before, but it bears repeating. When I bought my condo in Atlanta, I looked at the reserves and there was like $1 million in reserves. And I'm like, that's a lot of money. Great. Well, there were 300 units. And if they wanted to do anything at all, it was going to be minimum $5 million. So I just didn't have that perspective. And I think that's what it takes. As a follow up on the permit thing, Julie mentions that they actually will not let you do owner permitting for condos because they are multiple housing dwellings. They designate that differently. This would only be for single family. So Julie, I appreciate that distinction. Thank you very much for that. All right, so the last topic is maybe not necessarily a myth buster, but maybe it is. So someone early on asked about the NAR lawsuit with the DOJ about, generally it's about buyer commissions. So as you all are very aware, traditionally the seller pays commission to their listing agent. The listing agent agrees to share that commission with the buyer's agent, and that's just how it works. The buyers typically do not come out of pocket. Well, this lawsuit brought by the DOJ essentially says that that's not inherently fair. It's not. I don't know. I haven't read the entire lawsuit, but basically they're claiming that it improperly inflates the value of the property and forces the buyer to overpay. And so now they believe that in protecting the consumer, aka the buyer, that they need to go after real estate agents and brokerages to compensate those buyers, that they weren't disclosed this properly, that there weren't enough education about this topic. And already we've seen at least two major settlements, one most recently by Remax, another one by a brokerage that's a very large brokerage that owns like Coldwell Bankers and several others. And they're multi-million-dollar settlements. I think the Remax settlement was $75 million or something like that. So everybody, all the real estate agents, the brokerages have been paying very close attention to this. And I don't know exactly what will happen. I think if there really is major change, it'll be something along the lines of buyer will pay their agent and seller will pay their agent, and Fannie Mae and Freddie Mac will just have to figure out new rules. Because currently FHA and VA loans don't allow a buyer to pay commissions. So they'd have to change those rules. Buyer will pay their commission, seller pays theirs, and maybe that solves it. I assume this business is so agile, it'll flex. It's a very necessary part of this business. Most people buy a house every maybe 2 or 3 times in their entire lives, so they really can't do it alone. I think it's very important that real estate agents stay in this business. We just have to do a great job. We have to continue to educate. We have to provide service. We have to add more than we take away. Can't be
Yeah,
a
we
drag on.
had litigation like this years ago, Christian, on title insurance premiums, whether or not the purchaser, whoever was paying for the title insurance, had the right to negotiate with, say, us over our share of the premium. And it went all the way to the Florida Supreme Court, and the Florida Supreme Court said, yeah, they do. That you can negotiate and give to the buyer or the seller a portion of your premium. And there was a widespread panic among people who issued title insurance that this was going to affect their bottom line. Are we going to be able to make a living? Will we be able to pay our staff? Now here we are today, and it's made no difference at all, honestly.
Yeah. Yeah,
the market,
it might maybe helped with some transparency in the business. It's always helpful to, kind of look at those things over again. But you're right, it solidified the business rather than fractured it.
the water has to go somewhere, is the way I look at it. If you're going to reach a certain level, no matter what the route is, and buyers are going to need help, and the help is going to want to be paid. Will that affect
Someone mentions that it's their understanding that on commercial buyer brokerage agreements, the buyer pays the agent a commission. There's some truth to that. It actually works very similar to a residential buyer brokerage agreement. Basically,
Right.
the agreement says if the seller doesn't pay me a commission or share with me the commission, then the buyer will make up the difference up to whatever the stated agreement was. So let's say, Dad, I hire you as my real estate agent, and you say, look, I get paid 3%. That's your fee. So, all right,
Right.
you get 3%. So we sign a buyer brokerage agreement that says you're going to help me find a place. And if the seller doesn't pay you 3%, that I'm responsible for whatever you didn't get paid up to that amount. So that's on residential buyer brokerage agreements. It freaks a lot of people out because they don't understand that. In practice, what happens is that if we find a house and it's paying 2%, then that's where it ends. I'll just make 2%, or you'll make 2% on that deal. It kind of ends there. It is what it is.
Well, I honestly think that if the litigation prevails, and that'll just make buyer brokerage agreements normal. It's the only way
This would
the
be a great thing. I think that'd be great.
And it might ultimately be better for the realtor, because the client or the customer will not be able to drop that agent unless they violate the agreement.
Yeah. With the advent of technology and all these different, forces coming and going, this was inevitable. You and I talk about it. Buyer brokerage agreement is pivotal. It's key, and really, really important. So I hate that it doesn't get involved on more deals, but I understand that it just doesn't. And then there was a follow-up, and then we'll end. Can a seller refuse to pay buyer broker commission and still get their listings put in the MLS? So this is where the lawsuit comes from. So generally, most MLSs say you have to agree to share something with the buyer broker, including the local MLS. Local MLS says you have to put something other than zero in that column, but you can put $1. So you could, on an MLS listing, agree to pay the buyer broker a $1 fee from commission. That's possible. You just can't put zero. So I think if anything in this litigation, you'll see a widespread change to that where you can put zero. And whether the business will change from that or not, we'll see.
When I've seen that in the past, when you had low amounts going to the selling agent, I try to tell my owner, if there are if the selling agent has a client who's willing to spend $1 million, and they're looking through the MLS to see what's available, there's a natural tendency to go to the one where they'll get paid. They're not going to go to the one where they get paid $1.
Yeah. And if you have a buyer brokerage agreement, maybe it doesn't matter. But ultimately it does, you're not going to pay $1 million, you'll pay $970, and then you'll agree to pay your broker 3%. The big thing that'll need to change is mortgages. So mortgages will have to allow for paying commissions, and buyers might have to put less money down because they're going to be paying bigger fees. Maybe that's the solution. But we'll see. Time will tell. In the meantime, if you guys need any help, if you want to do closings with us, don't hesitate to reach out. We'd love to hear from you. Good luck. Thanks, Dad.